Edgar Lungu's eligibility to run in the 2026 elections remains a contentious and an ongoing legal issue. Now, Lungu served as the 60th Republican president from January of 2015 to August of 2021, assumed office following the death of President Michael Sata. After winning the 2015 presidential election and being re-elected in 2016, he was defeated by Hakainde Hichilema in the 2021 general elections. Now, the controversy centers on whether his partial term from 2015 should count towards a two-term limit stipulated by the Zambian constitution. The Zambian government recently announced a historic decision to broadcast live constitutional court proceedings, beginning with the highly anticipated judgment on former President Edgar Lungu's eligibility case. Now, this landmark hearing is set for December the 10th, that is Tuesday, this very week, 2024. Now, Endowment TV will be broadcasting these court proceedings live, and as a build-up to this, we have dedicated 90 minutes of airtime space daily to analyze the cases that have been brought before the Constitutional Court case. Before the Constitutional Court, we discussed the Danny Pule case on Friday. On Saturday, yesterday, we did discuss the Bumpy Kapalasa case, and tonight we focus our attention on the Legal Resource Foundation case, some of the arguments that were presented before court and how the court pronounced themselves. Tonight, I'm privileged to be joined in by State Counsel Sakwiba Sikota, who equally is a constitutional lawyer. Thank you so much, State Counsel, for joining me tonight on this program.
Yes, thank you.
I'm also joined in by constitutional lawyer in Mehluli Malisa. Thank you so much, Counsel, for making time to be with us tonight.
Thank you for having me.
Well, you too can be a part of the program by calling us on the number that will soon be reflecting on your screen as we talk understanding the Legal Resource Foundation case and the pronouncements that the Constitutional Court did make over this particular case. But let's recap on what the Inspector General of Police had to say around his expectations of people as they come on Tuesday, that is the 10th of December.
The service wishes to inform members of the public that the Constitutional Court proceedings scheduled for 10th December 2024 involving the former president, Mr. Edgar Lungu, will be broadcast live. In view of this, we advise the public to refrain from flocking to the court premises. We have credible intelligence that certain individuals are planning to cause disturbances during these proceedings. As a law enforcement agents, we want to make it categorically clear that any acts intended to disrupt public peace and order will not be tolerated. Those found engaging in such activities will be dealt with to the full extent of the law. The Zambia Police Service is fully prepared to ensure that law and order is maintained across the country. We appeal to all peace-loving citizens to go about their daily activities responsibly and to follow the court proceedings from the comfort of their homes or other appropriate locations. Let us all remain calm, respect the judicial process, and contribute to the maintaining of peace and unity.
Those are the words of the Inspector General of Police, obviously making known to the public of his expectation as Tuesday comes in the next few hours. Once again, legal experts, thank you so much for joining me. I'd love to begin with you, Counsel Malisa, of what you make of this statement from the Inspector General of Police. Obviously, some have come out in the open to state that there's no law that provides for barring people from attending the court proceedings before court. Before we can get into these matters that were before the Constitutional Court, what is your reaction to the strong warning that the IG has given to the members of the general public?
Oof, you put me on the spot. Okay. I think, like you said, generally our laws or the Constitution says that court proceedings are supposed to be in open court, which means they are open to the public, right? Anyone can go and attend court proceedings, ideally. But then you have a situation where maybe there is a lot of attention towards a particular case, like in this particular case, where there might be security risks, and of course, the courtroom can only take so many people. It can't take a multitude of people. So I think maybe the IG is coming from a word of caution with regards the security situation, that maybe we might have a security problem if, by sheer numbers, if we have a lot of people in the courts. So by luck, the proceedings will be broadcast on TV, so people can watch on TV, which is still the same as being in the courtroom. So I guess there are space considerations and also crowding and security issues. So I think it would be a good thing if people watch from the comforts of their home. There's not much space in the Supreme Court building.
Supreme Court building.
Yeah, I know that for sure.
But others argue that this is a case of great importance, especially the parties that are involved, and obviously these parties that are involved have their supporters, you know, who would love to be with them as they go to court, and the critics are coming in from that particular angle, that let those that want to offer solidarity to the individual in question come with these people. Maybe let me allow State Counsel to tackle that question.
I agree with my colleague completely that first of all, you've got to acknowledge and realize that all court matters are supposed to be freely attended by those who have got interest in them, unless they're being held in camera or unless they're chamber matters, in which case then they are restricted to the parties themselves and their lawyers. But otherwise, this case doesn't fall into that category. So anybody who wants to go there should be allowed to. Of course, the courts can only take up to a certain number. So it should be first come, first serve. And then once the court is full, the others should be turned away. Now, my problem with what the Inspector General has said is that from what we have seen in other cases, well, and in this particular case, in fact, you find that the police presence is so heavy out there. And you have to realize that it's not the only case which is happening at the courts. There are numerous other cases, and you find that people going for their other cases are not allowed to go in, they're harassed. Even lawyers, we were finding problems to get in there because of the kind of attitude that the Inspector General has got. So that is actually interference with the court process. What they should have done is merely encourage people to tell them that, look, there is going to be live and so on, there's no need for you to come there, but not to be threatening people and not to be putting hurdles for people who may be going for other matters. That is something which is really very sad.
So that's something that is really very sad. Let's quickly get into the matters of that the Legal Resource Foundation, together with Dr. Sakwiba presented before court. And obviously, first of all, the understanding from people would come from the fact that these were separate cases that were brought before court. The Legal Resource Foundation, Dr. Sakwiba as well, these are separate cases that the court said they would deal with them together. I think before we can get into these issues that they brought and the questions that were being asked, why was the decision of the court to put the questions together so that they deal with them, together? But let's begin from there, Counsel Malisa, in understanding what happens in court and people getting to follow really some of these decisions the court makes.
I think the answer to that, it's good that State Counsel was part of that case. He argued that case. But the answer is in the judgment itself. I think those who saw the petitions, like the petitions were almost identical, like word for word. That's what I saw. So in cases like that where you have, it was practically the same petition. If I don't know what State Counsel thinks, but that's what I think. It was practically the same petition. So it wouldn't make sense to hear the same matter in two different courts. So in such cases, the courts will do what is called a consolidation, which is what was done in this case, where the court decided these people are raising the same issue and they're asking the same question, but in two different petitions. So instead of the court God forbid, contradicting judgments on the same issue. So what happens? It's normal. It happens almost every time where the issues are the same. They're consolidated into one action. So there's nothing new there with what happened, because the issues were the same in the two petitions. And if you see the judgment, the judgment says the only difference in the petitions was just
the wording.
Yeah, on the names of the parties, but everything else was the same.
If I may add that the court system, for it to run efficiently, discourages multiplicity of actions. So if you're bringing actions and they are all seeking to address the same issue, it doesn't make sense to hear them separately. And have a multiplicity of actions. And of course, as stated, the risk as well of having contradictory judgments, because there's got to be certainty in terms of what the law is, and certainty and consistency from the courts when they make rulings on any matter. So seeing that all of these were basically about the same thing, there was no need to hear them separately.
Derek, let's quickly get to page 5 of the Legal Resource Foundation case, where we are now getting to look at the reliefs that were sought by the petitioners. And so the petitioners filed their petitions pursuant to Articles 1, Part 5, 2, 52, Part 4, and 128 of the Constitution, alleging that the first respondent, by filing in his nomination paper to the returning officer with supporting affidavit stating that he is qualified for nomination as candidate for president in the election scheduled for 12th of August 2021. You can come down, has contravened Article 106, Part 3 of the Constitution. The petitioner seeks the following reliefs. A declaration that the first respondent, having been elected, sworn into and held the office of president from 25th January 2015 to 13th September 2016, and having been declared winner of the 2016 election, sworn in into having held the office of the president from 13th September 2016 until the next president is elected under the 2021 election, is not eligible for nomination for election as president in the election set for 12th August 2021. B, a declaration that to the extent that the first respondent's nominations for election to the office of president scheduled for 12th of August 2021 contravenes Article 106, Part 3 of the Constitution, the said nomination is null and void. And C, an order of certiorari that the nomination paper filed by the first respondent with the returning officer and all documents in support of the first respondent's nomination for election to the office of the president in the election of 12th of August 2021 be removed forthwith into the Constitutional Court for purposes of question. Now, let's end it here, State Council. Obviously, the Court had pronounced itself 2 times in the Daniel Pole case, in the Bumpy Kapalasa case, and now in this case that we're about to look at how they pronounce themselves. How different were the matters that were raised in these 2 other cases with these reliefs that are being sought in the Legal Resource Foundation case?
When you look at the cases, there's actually no difference. The root of the cases is all about eligibility. That, when you boil it all down, that is what the cases are about. And the court has already pronounced itself on the eligibility. All you had is the parties coming back and trying to color it in a different way, but still basically asking about the eligibility.
Yes. Obviously, this was at the point when Edgar Lungu had filed in his nomination, and obviously there's an article in the Constitution that provides for one to go to court if they feel that a candidate does not qualify. And obviously they were relying on this very article.
Yes, they were relying on that article, but that question had already been dealt with. Whether they were doing it under Article 52, the question that they were bringing to the court had already been resolved and dealt with.
Councillor Malisa, these people are coming to court. Obviously, in the two court cases, the Daniel Pule case, the Constitutional Court pronounces themselves. In the Bampi Kapalasa case, the case gets to be dismissed owing to the fact that this case had already been dealt with. And now John Sangu and colleagues come to court challenging the nomination of Edgar Lungu. Paint it to us, perhaps, what the thinking of these petitioners, was in them going before the Constitutional Court to challenge, his nominations.
Yeah. If you listened to what State Counsel Sangwa said before he filed the petition, I think he wrote on Article 52(4) of the Constitution, which allows, if someone files in a nomination, there's a window that is given there for someone who wants to challenge that nomination. So you file your nomination papers with ECZ, and then ECZ accepts your nomination. Then the Constitution itself, under Article 52(4), allows anyone to go and challenge if they feel that ECZ accepted your nomination, but it wasn't valid or constitutionally so they can ask a constitutional question to the Constitutional Court. That is how the petitioners in the Sishua case moved. They moved under Article 52(4), which allows that. Yes, so that's why the court said they were properly before the court, because there is that window that says when there's a nomination that is put forward, anyone can challenge it, and it has to be disposed of within 14 days, I think.
21.
21 days, I think. So the correction,
From your endpoint, where do you think the confusion really, came about? Why were people still going before the Constitutional Court, even when there was a matter that was dealt in the Daniel Pule case? Could it be that perhaps maybe the Constitutional Court at that moment didn't deal with the issues? Obviously, the main issues, like you said, was around eligibility, and many of them were making reference to Article 106, around someone that has already held, that has been elected twice into office, can't run for re-election because the Constitution is very clear that you can only be elected twice into office. Do you think the Daniel Pule case adequately, perhaps State Council, dealt satisfactory with these issues around Article 106?
I think that it did. Maybe it's something that a number of people may not also have paid attention to, is that the Constitutional Court in the Daniel Pule matter decided to rephrase the question which was being put. The question which the petitioners put was very clear, and it was mentioning President Edgar Lungu. But the court said, no, we don't want it to seem like it's a personalized thing, and we'll just make it general. We'll take out his name. But that still shows that they were aware that they're talking about the candidacy of former President Lungu. And so when they made the decision, it covered him, and that's what they were dealing with, because that's what the petitioners had gone there for. You cannot then say that when you say you've found that there's merit, you then disregard what they had gone there for. They had gone there specifically about eligibility of President Lungu.
Why did the Constitutional Court change the question? Or did they change the question? Did they change the question?
They did rephrase it. They said they were rephrasing it because they said that they didn't want it to seem as if it is addressing just one particular individual.
What's the problem with that, State Council?
There isn't any problem with that, but then they decided that that is the way they would handle it. And so by saying that they didn't want it to seem like there's only one person, it doesn't mean that he is excluded from being covered by that. He's also included in that. And when you look at it in any event, there's only one person who would be affected by that, There's no other person who was going to be filing who had previously been under the Constitution which had been amended. There's only one person actually who would be affected.
For me, I would take a slightly different view from State Council. I would say in the Danny Pule case, the Constitutional Court, yes, it answered the question, but I think it didn't put it to rest. It didn't put it to bed. Like State Council said, they were asked a question, a direct question.
Direct question.
Is Edgar Lungu eligible? And the court decided, no, we don't want to personalize this question. We're going to make it of general application. And I think at the end of it all, the court, when it pronounced itself, it said the term of office that straddled two constitutional regimes does not constitute a full term. And that's where the court ended. But the question was, is Edgar Lungu eligible? I think the court should have just answered yes or no. It would have put the matter to rest in the Dan Pule case. Okay? But if we go forward to the Legal Resources Foundation case, I think the court answered the question because it was a direct question and the person affected was a party in that case. And so the court gave a direct answer to say, we think this person, or okay, not that they think, they said this person is eligible to stand. That's what the court said. Yeah.
Maybe to a layman, maybe help us understand, counsel. Under what circumstances can the court change a question that you brought before them?
Okay. Look, I think the courts, when they are presented with questions, right? Most of the time, sometimes the court can actually craft its own questions from what you have presented to it, okay? This is how they understand the questions that you are bringing to them. So I don't think there's anything wrong with that, with the court changing the question, okay? There's nothing wrong. But then at the end of the day, I feel that even if there's nothing wrong with changing the question, I think generalizing it, well, it was well intended because the court was trying to cover, it was looking forward to say, oh, what if somebody else gets found in this situation who is not former President Lungu? Okay, so they were trying to cover the whole area. But now, what it resulted into was that the question was not directly answered. But to answer you, there is nothing wrong with the court changing the question according to how they think it is presented to them.
Another question, I think this
Maybe
also...
before you move to that, I would argue, and I agree, that there's nothing wrong with them changing the question. But I would argue that what they did is they expanded the question to cover more than just former President Lungu. So by expanding it doesn't mean that they've taken him out. So in my view, even though they answered the expanded question, it covered President Lungu as well.
What could have been the intention? The intention could probably be that in case anybody finds themselves in this situation, this would apply to them, isn't it?
Yes.
Another issue that is very important, and I think this is a question also that Bampi Kapalas and Joseph Sengat asked in their reliefs. They say that whether or not the provisions of Article 106 Part 3 and Article 106 Part 6 are in conflict with one another, and if so, which of the two articles ought to take precedence over the other, and whether or not the provisions of Article 106 6B ought therefore to be struck down for being in conflict with the expressed will of the people of Zambia not to allow any person to hold office as president or be elected as such more than twice. State Council. How would you break this down to a layman? Because when a layman reads the Constitution and when they see that you can only be elected into the office of president twice, and now there's an individual who wants to be elected 3 times, or more. Now they're asking, is the Constitution in conflict? Because there seems to be inconsistencies, and obviously the Concord pronounced themselves over this matter. But to make people understand, you know, the rationale of someone really saying that, look, there seems to be inconsistencies because one could only be elected into office twice, but there's an individual who wants to be elected 3 times.
No, thank you. I think that when you look at our constitution, it does actually envisage that you can be elected 3 times. It does. Because if you look at Article 106, sub-article 6A, it says, for the purposes of clause 3, which is the one which says a person who has twice held office as president is not eligible for election as president. That is very clear. And then it says, for the purposes of clause 3, and then if you go to A,
at 106, right?
Yes.
Okay. You can go to Article 106, Director of the Constitution.
6A. To have served a full term as president, if at the date on which the president assumed office, at least 3 years remain before the date of the next general election. So, if the term was less than 3 years, that person would still be able to stand. And if you recall, former President Lungu's first tenure was 1 year and some months.
Months.
Yes. So there's that provision which allows for somebody to actually stand 3 times if they so wish.
Councillor Malisa.
Yeah, I would say that there is no contradiction. Because your question was, in the Pampi Kampalasa case, they asked if there was a contradiction between 1063 and 1066. Okay? State Council said there is no contradiction there. It's straightforward. Okay? 1063 says a person who has twice held office as president is not eligible for election of president. So the question is, what does holding office mean? So when you come down here to Article 1066, the one that State Council read, it talks about, I think if you go back, it says, if the vice president assumes the office of president in accordance with clause 5A, or a person is elected to the office of president as a result of an election held in accordance with clause 5B. Now, the whole Article 106 gives a sequence of what happens should the office of the president fall vacant. Okay? So, when you look at this, for me, I think the question they should have asked was whether this Article 106 applies to President Edgar Lungu, because at the time President Edgar Lungu was elected in 2015, this Article 106 did not exist. It was not there. Okay? And if you look at it carefully, it envisages a situation where we have a running mate who is the vice president, right? So it means that the president and the vice president are elected together, right? Because when you vote for the president, you also vote for his running mate, right? So which means the vice president is also voted for, which was not there before the 2016 amendment.
How was our court applying themselves here in arriving at the decision? For example, in the Dani Poli case, were we using both the constitutions that ushered President Edgar Lungu into office and the new constitution of 2016? Were we using the 2 constitutions to arrive at the decision, State Council?
Yes, they looked at both constitutions because one was elected under one constitution and then second time round under the other constitution. And so now they were looking at now do those terms mean that he's disqualified under the second constitution, or because they straddled two, it's still okay? And their ruling was that when somebody has straddled the two, they still qualify.
The argument also, Councillor Malisa, that we cannot use the law in retrospectively. How does that argument, come to play in the case of President Edgar Lungu?
Yeah, I'd like to put it into perspective that the constitution we're using is still the same constitution. Okay, it's the 1991 constitution. It was amended in 1996. Okay, and then it was also amended in 2016. But it's still the same constitution. It's one constitution. So now, what State Council was saying is that President Lungu, former President Lungu, was elected before the 2016 amendment for his first stint in office in 2015. It was before the constitution was amended. Then in 2016, the constitution was amended. So now, there were provisions before the amendment. Now, there are provisions after the amendment. So now, you're asking me if Article 106, which came into effect in 2016, how was it used to apply to something that happened before it came into life? That's the question you're asking.
Yes,
me,
yes,
right?
yes.
Are you asking for my view, or you want to hear what the court said?
Your view and what the court said.
Okay, so let's start with what I think. What I think is that I feel that that's what I think.
Yes.
It shouldn't have been the case. Because if you look at Article 106, 6, right?
Yes.
It says, if the Vice President assumes the office of President in accordance with Clause 5A, right? What does Clause 5A say? It says, when a vacancy occurs in the office of President, except under Article 81A, the Vice President shall immediately assume the office of the President, or if the Vice President is unable for a reason to assume the office of President, the Speaker shall perform the executive functions. Right. If you go back to 2015, none of this happened. Right. Of course, the President died, and the Vice President, Dr. Guy Scott, that time, took over in an acting capacity for 90 days, and then a by-election was held, because that is what the Constitution demanded then. This clause was not there. So now, for you to apply this Article 1066, I think all these conditions must be met, okay? The Vice President must take over. But at that point, we didn't have a running mate as a Vice President, so it couldn't happen. So my take is that applying Article 1066 retrospectively, if I was the judge, I wasn't going to do it. But this is what the court said, and what the court said is what matters. What the court says is the law, not what I say. So the court said that because the term, the first term and the second term of President Lungu straddled these amendments, then they applied this Article 1066 to that situation and said, okay, because he took over a term from a president who died in office, and then he was only in office for about 1 year, 8 months. Then according to Article 1066, because the period he served in office was less than 3 years, then it does not count as holding office. Hence the conclusion that he was eligible. That's how the court went around it.
In the Bampika Palasa case, the court also says that there's a possibility that one could serve for even up to 13 years. Like we say, then that the only possibility is that they could be elected 3 times. Is there a way that this could be cured? Because critics argue, State Council, that the framers of the Constitution, what they had in mind is that one should serve a maximum of 5 years. I mean, for a term, and for a full, that it should be 10 years. Is there a way that this then could be cured for us to avoid being at a place where we are today?
The first question is there something that needs curing? Because I think that, yes, generally, they're saying that you should only serve 2 terms. Generally, that's what the Zambian people were saying. But then they're also looking at a situation where, let's say, just 100 days before, that is when you come in. It would be very unfair that you'd only be entitled to have 5 years and 100 days when others can have more than that. And I think that's why they said that, well, if you hadn't served in that first instance more than the 3 years, then you're still entitled to. And I think that's what the Zambian people said through their representatives. So that's why I'm asking to say, I don't think that there's anything that needs curing, because I don't think that that proposal is unreasonable or it needs any curing. That's my own view.
Let's get to the judgment of the of the Legal Resource Foundation. If you can go to the last page, page 23, page 83 rather. Director, please let's go there. So start from here. The court argues that the argument that length of time served in office as president does not matter is at variance with the clear provisions of Article 106, Part 6 of the Constitution, which clearly spells out what constitutes a full term of office for purposes of Article 106, Part 3. It therefore cannot be argued that the phrase twice been elected as president and the phrase has twice held office mean exactly the same thing. While we agree that both phrases were intended to limit the number of times a person can hold office as president, there is a clear distinction in the effect of the 2 constitutional provisions when they are read in the proper context. Under the repealed Article 35, Part 2, it was sufficient for a person who has been elected twice as president to be barred from further standing for election as president. However, with the advent of Article 106 read as a whole, the position has completely changed. It is not sufficient that one has been elected twice to be barred from further standing for office as president. A determination of whether one has twice held office goes beyond one having been elected twice. It is to be determined with reference to the term of office as defined by Article 106 Part 1 and Article 106 Part 6 of the Constitution. We pronounce ourselves on the holistic interpretation of Article 106 in the Daniel Pole case, which interpretation were reiterated in the case of Kapalasa. We reiterate that to argue, as the petitioners did, that Article 106 Part 3 of the Constitution applies to the inherited term served by the first respondent from 25th January 2015 to 13th September 2016, but that Article 106 Part 6 does not, is to isolate Article 106.3 from the rest of the provisions in Article 106, which is unattainable at law, and is at variance with the tenets of constitutional interpretation. All the provisions of Article 106 on the tenure of office of the President must be read together. We emphasize, as we did in the Daniel Pole case, that the provisions of Article 106 Part 6 of the Constitution regarding the full term must be applied to defining what is meant by twice held office, and Article 106 Part 3 in interpreting the provisions of that article. We wish to add, in relation to the import of Section 7 of the Constitution of Zambia, Act No. 1 of 2016, which we considered in the Daniel Pole case, and which provided for the continuation in office of President, that to provide for the President's continuation in office is not the same as to provide for how that specific term, which was less than 3 years in duration, was to be treated. It was necessary, in our view, for the framers of the Constitution and Parliament, which enacted the Constitution of Zambia, Act No. 1 of 2016, to make adequate transitional provisions with respect to that term, particularly in light of the changed constitutional regime regarding how an inherited term of office was to be treated, as Article 106 Part 6 of the Constitution clearly states that a full term of office is for purposes of Article 106 Part 3 of the Constitution. It is not disputed that the term which the first respondent served from 25th January 2015 to 13th September 2016 was an inherited term and not a full term as defined by Article 106, Part 6 of the Constitution, which hold that the presidential term served by the first respondents from 25th January 2015 to 13th September 2016, when considered in light of the intention of the framers of the Constitution and on the holistic approach we took in interpreting Article 106 of the Constitution in its entirety, the Daniel Pole case cannot be considered as a full term for the purposes of Article 106. Council Malisa, help us understand here what the Constitutional Court is trying to is trying to pronounce. Should then we say that between 2015 and 2016 we had no president because President Edgar Lungu inherited the other part which was supposed to be finished by President Sato?
No, we can't say that. We can't say there was no president because the president...
So should we say that that was President Sato's term? It wasn't President Edgar Lungu's term?
Look, what the court is saying is that you asked me what the court was saying,
yeah,
not what I think. What the court was saying here was trying to say that Article 106, okay, the whole Article 106, there is Article 106.3,
yes,
which talks about twice holding office. The court was saying that you cannot isolate it from the other parts of that same article because they're all sitting in the same Article 106. There's Article 106.3 and there's Article 106.5 and there's Article 106.6. So the court was saying for you to get the context, you need to read all of them together because they are interconnected. So 106.3 says that a person who has twice held office is not eligible, right? Then Article 106.5 tries to bring in a situation where somebody assumes the office of president when there is a vacancy, like what happened, a president dies. And then because under this dispensation, we have a president right now, right, who was elected together with his running mate.
Yes. Right?
So God forbid, if something happens to the president, the vice president automatically gets into that office using Article 106.5. Right. Okay. Now, how many, let's say it happened today.
Yeah.
How many months or how many years are remaining to the next general election? Okay. So what happens is because the president right now and the vice president were elected together, they were running mate. So the vice president also has the mandate of the Zambian people because the Zambian people elected her. Okay? Understand that. That is the context of this article. Now, if such a thing happens today and then we are less than 3 years away from the next general election as it is now, we're about 2 years away, right?
Yeah.
So what would happen is that the vice president will take over and take us to the next election, which is in 2026. Okay? So should the vice president decide to stand now to become the president in 2026, right? She'll be eligible, right?
Yes.
Now, should she want to stand in 2031? Okay, now the question will come to say, okay, you, first of all, you held the office of the president when the president died. You entered the office.
Yes.
You were not elected, right? Because you were the vice president, you just took over. Now, according to this article...
You earlier said that when we were electing the president, we're electing them together with...
Yes. Yes.
So which means they were elected together.
Yes, she was elected as vice president, right?
Oh, okay.
Then she assumed the office of president because the office became vacant. Okay. So in a way, they were not elected; they ascended. Okay, the correct word is ascended. They ascended to the president, right? So what it means now, we'll come back and say, okay, so in this is 2024.
Yeah.
In 2024, you became president. Okay. Now, there were 2 years remaining to the next election. Okay, so it means that these 2 years now, for purposes of the two times of holding office, according to Article 106.6, will not be counted. So the vice president will be allowed to stand again in 2031, which means if they win, then they will have done 2020. Yes, 12 years. This is what the Constitutional Court said in the Bumpy Kamparasa case, and this is what they were trying to say in the Legal Resources Foundation case. But what I agree with them, by the way, that if you use Article 1065 to ascend to the presidency, then Article 1066 applies to you. That I do not dispute whatsoever. That is on point. That is how I understand what the court said. However, I think the debate has been, I think, for people not to be confused, the question that was raised in the Legal Resources Foundation case was that, does this 106 apply to someone who was elected when it did not exist? Okay, right now it exists, so there is no problem. It's straightforward. But the problem arose, or what you call the confusion, what they're calling lacuna or whatever, arose because someone was elected in a different dispensation where this 106 was not there. Okay? The president, the former president then, when President Michael Sata died, the vice president was Dr. Guy Scott.
Yes.
Right? So 1065 says when the president dies, the vice president has to take over. Right? In that case, the person who took over was Guy Scott in an acting capacity under Article 35 then.
Yes.
Right. Now, this Article 106 was not there. Okay.
Which provided for a running mate, isn't it?
Yes, it was not there.
That's why we had to go for an
It
election.
only came in 2016.
That's why we had to go for an election.
Yes. So now the confusion, and maybe State Council may help clear this out because the State Council was part of the case. The confusion, I think, what most people are calling confusion, arose on the part of, okay, when President Edgar Lungu was first elected, when he didn't have a running mate, he was elected alone, okay? He did not inherit anyone's term because he was elected himself. President Lungu did not become president immediately after President Michael Sata. That is not true. The one who became president after President Michael Sata was Dr. Guy Scott in an acting capacity. And then the country went to a by-election. And President Lungu was elected himself. He didn't have a running mate. He was alone. Now, we come 2016. Article 106 is now there. And it says, if something happens to you, then your running mate takes over. Now, when President Lungu was elected in 2016, yes, he had a running mate. That is straightforward. But in 2015, he did not have a running mate. So that is where the issue was. And I think that is the question that the court was trying to answer. To say, we cannot have a vacuum. We cannot have, we have to fill in the blanks. And in filling in the blanks, the court came to the conclusion that Article 1066 equally applies to that term that straddled two constitutional provisions, meaning that because it was less than 3 years, then it does not count as a full term.
If I may come in, your question was, did we have no president for 1 year, 2 months? I think that's what. I think that there's never been a time when we didn't have somebody exercising the powers of the presidency. Even though there is that famous book which was written in the 70s, A Night Without a President, we've never actually had that because immediately, whether the person dies, resigns, or whatever, somebody moves in an acting capacity. So you cannot say that for the 1 year, 2 months, we didn't have a president. We did have a president. I just wanted to have that.
In conclusion of this matter, of the Legal Resource Foundation, the court says, for these reasons we've stated above, the ones I read, the petitions have no merit and are therefore dismissed. Obviously, because of what you mentioned, State Council, that all these were bordering on the eligibility, and obviously this goes to Article 106. Under what circumstances can now the court reopen this matter that has dealt with eligibility when we're speaking about Edgar Lungu? Let me begin with you, Counsel Malisa. In the Bumpy Kapalasa, the court, I asked yesterday that the court has emotions because it said that it frowns upon individuals that want to have a trend of bringing cases that have already been dealt with. The court said it frowns upon such behavior. And now, obviously, there's this. We're not getting into the Chizombe case. I have the questions that Chizombe is asking before court. But if it has to deal with Edgar Lungu, then what angle really could be taken to deal with eligibility? Because if you read this court case, it says if you are going to bring this case around the eligibility of this guy, this court has already pronounced itself holistically. Actually, it mentions that holistically. Under what circumstances, really, could we even hear preliminary, because the preliminary issues were raised, and the court heard the preliminary issues. Maybe without getting into the matter, help us understand this, Hans.
Okay, first of all, I cannot talk about the case that is currently before court, because that will be sub judice, and I don't want to go in front of the court. Okay. We'll go back to the case that was already decided by the court. And as you rightly put it, in the Kampalasa case, the court actually threw out the petition because the court said it had already decided the case in Danpole. And that is an entrenched position, I think, in our jurisdiction, that you can't keep on litigating the same issue over and over and over and over. The courts are actually, if I say they frown at it, I would be making an understatement. They don't want that. Actually, it's an abuse of the court to keep on asking the court the same question, and you want the court to keep on answering the same question until you get a different answer. So the rationale is, even if the court gives you an answer that you don't like, okay? In litigation, there's a winner and there's a loser, okay? If I do not agree with the decision of the court, like I said here, I do not agree in the substantive decision of the court, but it does not mean that I should keep on going to the court and asking it questions, especially a court, as State Counsel Sangwa says, the Constitutional Court can do no wrong. So the Constitutional Court can do no wrong in that there is no appeal against the decision of the Constitutional Court. So once the Constitutional Court makes a decision, its decision is final. Finality means that I can't go anywhere. So I just have to accept that decision, whether I agree with it or not. Okay? So if I don't agree with the decision, for a decision of a final court like the Supreme Court or the Constitutional Court, then it becomes a matter of academic discourse, because then we start writing articles now critiquing the judgment to say we don't agree with this. Those who are in academia will understand that you can actually critique a judgment of the court. You can actually criticize it and say, no, this was wrong. But what the court has said is what is binding. So the courts, the principle, they
so
call
it doesn't matter whether
judicata.
it doesn't matter whether the error becomes law.
Yeah, it doesn't matter, because what the court says, whether it's right or wrong, it's what the court has said. What the court has said is the pronouncement of the law. But you should understand that courts are manned by human beings. Okay, they're human beings. They are not AI, they are not machines, they are not robots. So even if, okay, maybe there was some error or whatever, but the point of the matter is, just because you do not like a final judgment of an apex court, you can't keep on going to ask it same question. There has to be an end to this thing. There has to be finality to litigation. That's what they call res judicata. The matter has to rest. The matter has to finish. Of course, someone will be unhappy, someone will be happy. But the bottom line is, the matter has to end.
State Counsel, under what circumstances can, for example, the Constitutional Court relook at the decision that they had already pronounced themselves on? Under what circumstances?
I'll get to that, and I'd just like to pick up and say that I think that what State Counsel John Sangwa has done clearly demonstrates what the law is. State Counsel Sangwa argued very, very brilliantly and forcefully in all of these matters, and arguing that former President Lungu is not eligible. He argued that very, very strongly. After the judgment has been made if you go and ask State Counsel Sangwa what the law is in terms of eligibility of a former president, he'll tell you former president is eligible. But it doesn't mean that he didn't hold that strong view. Maybe he still even holds that strong view, but he recognizes that the law has been settled and that is the position. And that is what brings about stability in our legal system. Otherwise, there would be no finality to litigation. After the 10th December, whichever way it goes, whoever is not happy would then bring the same case up again. And where would it end? Where would it end? It wouldn't end. And so coming to your question directly as to under what circumstances, I think that it is very, very, very limited. You have to show that there is something new, something which has not been covered in the other judgments. That is when you can look at the matter again. Without that being there, you cannot. And you did mention that there are some preliminary issues. One of them touches on that. The court said that they would not rule on that preliminary issue. They would rule together with the main judgment.
Under what, well, State Counsel has given his position over the law. Is there precedence really to, well, I know that the Constitutional Court is technically a new court, you know, but do we have precedence so far where the Constitutional Court has re-looked at their decision and, for example, abandoned the earlier decision?
The Constitutional Court, I don't think there is so far, because the Constitutional Court is still new.
Yeah.
But there are a few cases from the Supreme Court where the Supreme Court has departed from its previous position. But like State Counsel said, it's a very narrow window where the Supreme Court can actually be convinced to abandon its earlier decision. Yeah, but it happens sometimes, and you need to have convincing and compelling reasons. Maybe to say there's some new issues that have arisen, something has changed, or that a great injustice was done, okay, by continuing that precedent. And the Supreme Court has, it's usually very, very reluctant to abandon its previous position, because that's what, like State Counsel says, it brings about stability in the legal system. So the legal system actually thrives on stability. Actually, stability is very, very, extremely important, especially when you're dealing with the apex court, where you have no appeal. Because you can't be having the apex court changing its decisions every day. Then it makes it difficult even to argue cases, because you don't know how they're going to decide, right? So it's, yes, it happens, but in very rare cases.
I don't know if this would be contemptuous. If it is, you shouldn't answer the question. But there's been discussions around what the possible implication would be. For example, if the court departs from its earlier decision over the elections of 2021. Others have argued that the elections of 2021 then were nullity because someone who didn't qualify participated in that election. I don't know if this could be looking at both outcomes. State Counsel, I don't know if this is contemptuous to look at the implication of, for example, I know you explained of how this then opens a Pandora's box where anybody now could go before the Constitutional Court to say, no, I also think this is what you should have argued, you should have, pronounced. But what could be the implication really if, for example, this matter is decided upon differently?
It's interesting that you have asked that question. As you know, State Counsel Sangwa was allowed to makes submissions as a friend of the court. And his submissions are actually on centered mostly on that very point that you've raised as to what would be the implications if the court was to say former president was not eligible. The court says that it has taken it will take into account what State Counsel Sangwa has filed. But during the process, they did not allow State Counsel Sangwa to expand on his written submissions to the court with regards to that matter. They simply said, we've heard what you have written. And what was of concern to me, not so much them saying he cannot expand, but the other parties to the matter, both the petitioner and the respondents, the deputy president actually specifically stated that they would not be allowed to touch upon the submissions that State Counsel Sangwa had put forward. That struck me as odd in that if you were allowing State Counsel Sangwa to bring those arguments, it means that you felt that the issues he raised were connected and should be addressed. Now, if that is the case, I fail to understand why you then tell the actual parties who are interested that you cannot speak or submit to us on that. That struck me as odd.
Is that new?
What do you mean?
Is that unusual?
I think it's unusual, because you have to hear all the parties. If you're saying that, because the State Counsel Sangwa applied to say, I would like to join as a friend of the court and to bring these issues to this case. The court looked at it and said, yes, you can come and join in and bring those issues to this court. Now, the unusual bit is that after you have said that, you then tell the litigants that, no, you cannot address us on what State Counsel Sangwa has brought. I think that was, in my view, odd.
Counsel, well, State Counsel was giving the arguments that State Counsel John Sangwa was given in court. But what would be the possible implications, really, if this would go the other way, where the court departs from its earlier decision?
Look, I do not want to speculate, like I said, on a matter that is currently pending before the courts. But you're asking me about possible scenarios of what would happen.
Yes.
I really don't know. And then he asked me to look into a crystal ball.
Yeah.
I don't have one. But yeah, so your guess is as good as mine. We're also waiting for what will happen on Tuesday.
How important, is this Tuesday case to the legal fraternity? How critical and important is this case?
I don't even know which word to use in terms of its importance. And the fact that you have dedicated almost an entire week just talking about this case shows the magnitude of how important it is. It's not only important to the legal profession, I think it's important to the whole country, actually, because I think in as much as the litigants are before the court, I think our entire system of governance is actually at trial. The whole system, starting from the judiciary, the executive, all of us, the lawyers, our electoral system, and all those things. Our constitution is under the microscope. Maybe the question would be, what happens in terms of judicial stability? Number one, which direction is the judiciary going to take? Are they going to take the route of stability, or if they feel that they were wrong in their previous decision, they're going to try and correct themselves? Which one of the two? Okay, so and everyone is watching because we want to see what direction the Constitutional Court is going to take. Are they going to preserve the decision that they've stood by 3 times now? This is the 4th time of asking that they've been asked this question. They've answered it 3 times. This is the 4th time. We want to know whether this will be the last time or it will come again. So you see, everyone is on the edge of their seats. So it's so important, and yeah, it's a good thing that the judiciary has asked for the first time that cameras go into court. They could have gone much earlier during the proceedings so that we appreciate the arguments from both sides. It would have been a very good thing. But we hope going forward, matters of national importance like this one, I think give a chance to the Zambian public to have their own view based on what they're seeing unfolding in the courts of law.
State Counsel?
I'd go even a bit further and state that it's not only in Zambia where there is interest. The interest in this case is actually even beyond our borders. If you look at the press all over the world, they are reporting on this matter. It shows you the importance of the matter, that it is global. It's not just national. It's global. And I think that it is also very, very important and interesting in that the court will then be telling us under which conditions one can reopen up a matter. Because that is of great interest to us as lawyers, so that we would know. For example, I'm not saying that they are going to say they are reopening, and I'm just saying it from purely an academic point of view. Let's say one can reopen easily. Maybe you'll find one of the ministers who were told that they need to repay the monies that they had, who were not heard, by the way. They were not part of the action. Then they'll say, in that case, let me bring my matter of the refund of the money to the Constitutional Court. That's just an example. There are many other people who may then say, in that case, let me bring my matter
to the Constitutional Court.
To the Constitutional Court. So those are the kind of things that will need to be weighed and looked at, because what will be good for the goose will certainly be good for the gander.
That's true. State Counsel Sakwiba Sikota, thank you so much for coming tonight.
Thank you.
Constitutional lawyer Mehluli Malisa, thank you so much for making time to explain some of these technical issues in the Legal Resource Foundation Limited and others tonight.
Thank you for inviting us.
Well, there you have it. We've been discussing the Legal Resource Foundation Limited and 2 others case that was brought before the Constitutional Court. Obviously, the Constitutional Court did dismiss this matter, stating that they had already adjudicated upon this matter in the Daniel Pule case and that this case had no merit. We continue with the eligibility countdown case tomorrow at exactly 12 hours and again at 21:15, as now we look at, not discussing, but look at the questions that have been presented in this case. Chizombe is presenting some of the new questions before the Constitutional Court. We look at the questions that he's asking, and as we await for Tuesday, as we bring you live the broadcast in the Constitutional Court. Diamond TV is going to be broadcasting live from the time that we're going to start at 9 hours in the morning. We're going to be doing a build-up, obviously from Edgar Lungu's residence, from here at Diamond TV, and from the court process. And so it's going to be a full-packed day as we really look at the decision and how the Constitutional Court is going to pronounce themselves. On behalf of the entire production crew and my guest tonight, thank you so much for watching. See you again tomorrow as we continue discussing the ECO eligibility case. Good night.
Tembo Banda.
Messi Chibuye Nyati.
Tieni tipitilize kutandala.
Madiva Mukomboni Neshta ya 12 hours up to 14 hours.
Tieni tipitilize kutandala. Pa Thursday kunena kutipa chinai. Nandawi ya 12